second case on our docket is 19-60553. It's Cortez-Ramirez versus Garland. Mr. Miller.
May it please the court. I am Ross Miller, and I represent the petitioner in this case, Melvin Alexis Cortez-Ramirez. Since he was just 6 years old, petitioner has been a devout evangelical Christian in his native El Salvador. As a result of his beliefs, petitioner actively worked to ensure that criminal gangs' authority in his country was limited. Unfortunately, as a result of his beliefs, petitioner became the target of criminal gangs, with 2 of his cousins even being murdered because of their evangelical beliefs. After enduring a continuum of threats and acts of physical violence, petitioner was finally forced to flee his country of origin for the safety and security of the United States, where he subsequently sought asylum, withholding of removal, and protection under the UN Convention Against Torture. At its heart, Your Honors, this case is about giving effect to the plainly expressed will of Congress to protect refugees like petitioner who are persecuted because of their faith, politics, and family ties. Petitioner respectfully requests that this court reverse the decision of the board and remand his case back to the agency for 2 reasons. First, because the board misapplied the burden of proof standards to petitioner's asylum and withholding of removal claims. And second, because the evidence of record in this case compels the conclusion it is more likely than not petitioner will be subjected to torture in his country with acquiescence or willful blindness of the government. The first issue is resolvable by an analysis of congressional intent, as it has been codified by the Real ID Act of 2005. That act, as it relates to immigration, was primarily concerned with ensuring that terrorists could not abuse the nation's immigration system. To that end, Real ID introduced new standards governing credibility and corroborating evidence. Real ID also sought to address the question of how to adjudicate asylum and withholding of removal applications where the persecution alleged is premised on both statutorily protected and non-protected grounds, also known as mixed motives cases. Adding clarity on this point, to qualify for asylum, Congress required that a protected ground be one central reason for the persecution endured. To qualify for withholding of removal, however, Congress only required that the protected ground be a reason, which is clearly a lower burden of proof standard to establish nexus. And Your Honors, the plain language of the statute brings me to my first point, and that is that Congress clearly requires applicants for asylum and withholding of removal to meet different burden of proof standards to establish the nexus elements in their claims. As the U.S. Court of Appeals for the Ninth Circuit noted in the 2017 case Barajas-Romero versus Lynch, the plain language of the statute is unambiguous. A reason governs nexus for withholding of removal, and one central reason governs nexus in the asylum context. And Your Honors, this interpretation is inherently reasonable. As the Ninth Circuit aptly noted in Barajas-Romero, in order to establish eligibility for withholding of removal, an applicant must show it is more likely than not he will be persecuted. However, to establish eligibility for asylum, the same applicant would only be required to show a well-founded fear of future persecution. As the U.S. Supreme Court noted in the 1987 case INS versus Cardoza-Fonseca, the well-founded fear threshold can be met by a mere 10% chance of persecution. In light of this reality, the Ninth Circuit in Barajas-Romero concluded that since Congress clearly wanted a higher burden of proof to establish persecution in the withholding context, it specifically diluted the nexus standard in order to ensure against accidental removals where a protected ground is at play. Similarly, Your Honors, in the 2020 case, Guzman-Vasquez versus Barr, the U.S. Court of Appeals for the Sixth Circuit agreed with the Ninth Circuit's reasoning in Barajas-Romero, finding first that the statutory language is unambiguous. A reason governs withholding of removal nexus, and one central reason governs nexus in the asylum context. But the Sixth Circuit also went on to conclude that the board's decision in the 2010 case, matter of CTL, in which the board uniformly applies the asylum statute's one central reason nexus standard to both asylum and withholding of removal, was not reasonable and was thus not entitled to deference. According to the Sixth Circuit Court of Appeals, that decision wasn't reasonable because these are two different statutory forms of relief with different eligibility requirements and different benefits conferred. For example, a non-citizen who is able to obtain asylum relief is able to adjust status to lawful permanent residence after just 1 year as an asylee, whereas an individual who is granted withholding of removal is not eligible to adjust to lawful permanent residence, and in fact, can still be removed to a safe third country. Additionally, although a variety of statutory bars apply to both asylum and to withholding of removal, such as certain criminal bars and bars against individuals engaging in persecutory misconduct, a wider variety of these bars apply to asylum than they do to withholding of removal. Withholding of removal is a mandatory form of relief, whereas asylum is a discretionary one. According to the Sixth and Ninth Circuits, these are different forms of relief, different eligibility requirements, different persecution elements, different nexus elements. Your Honors, petitioner contends that this is an inherently reasonable interpretation of the statutory language, and he requests that this court recognize that the board erred in applying the asylum statute's one central reason standard to both his asylum and withholding of removal nexus claims. But Your Honors, even if this court concludes that one central reason governs both forms of relief, petitioner can clearly meet the one central reason standard necessary for asylum. As the record indicates on pages 115 to 123, petitioner actively worked in his country to evangelize fellow youths to turn away from the influence and authority of criminal gangs. During this process, 2 of petitioner's cousins were murdered because they either refused to join a gang or they refused to remain in a gang. And after their murders, petitioner himself was subjected to death threats and acts of physical violence because of his faith and his politics. Petitioner, the record on pages 115 to 116 specifically shows that petitioner was initially targeted, it looks like, for a robbery, and he was assaulted and robbed.
Is there any evidence that the gangs here are just, or on the other hand, generally in San Salvador, are religiously hostile?
Well, Your Honor, the evidence of, yes, there is evidence that the gangs demonstrate hostility towards gangs in El Salvador. The record on pages 356 to...
No, I can understand how a gang would be hostile to an individual who happens to be Christian. But what I'm asking, is there an underlying thread of the conduct or philosophy, to the extent that they may have any, of a gang that is negative toward religion?
Well, not necessarily in terms, the record doesn't establish that the gangs have a necessary philosophy that is opposed to religious adherence in El Salvador. However, the facts of this case compel the conclusion that that is, in fact, the reality of petitioner's situation. Your Honor, the record indicates on pages 115 to 116 that petitioner was robbed and assaulted by gang members who stole his cell phone, and that during the course of the robbery, after they took his cell phone, the gang members asked petitioner if he himself was a member of a gang. And petitioner responded that he wasn't a gang member because his faith and his beliefs precluded him from joining a gang or from furthering gang motives. As a direct consequence of that expressed opposition, petitioner was beaten and was threatened with death. There's no evidence around that event that gang members tried to recruit him or that gang members were furthering any other general criminal motive since they'd already robbed him. So petitioner would maintain that this evidence of record simply compels the conclusion that he suffered persecution on account of his political beliefs and his religious beliefs, which were expressed to his persecutors. And Your Honors, petitioner would also note that Although El Salvador, the record demonstrates on pages 355 to 364 that the country suffers, unfortunately, from widespread acts of gang-related harm and criminal victimization, this reality in and of itself doesn't mean that petitioner's claim is negated. As this court noted in the 2004 case, Edouard versus Ashcroft, a reviewing court is still required to conduct the requisite nexus analysis in order to determine why exactly an applicant for asylum or withholding of removal was protected. And in this case, again, the evidence of record compels the conclusion that he was persecuted because of his protected grounds. But Your Honors, even if this court finds that petitioner cannot establish.
What protected ground are you claiming other than religion?
Religion, politics, and a family-based particular social group membership, Your Honor.
Okay,
So,
and what is the basis for the family, the nuclear family, or whatever it may be referred to? What is the basis for the hostility there?
Yes, Your Honor. Petitioner was an active member of his church, and his family were active members of his church. And they were recognized in the community because of their evangelist activities in the broader community. And he maintains that criminal gang members targeted and murdered two of his cousins, once again, because of their opposition to criminal gangs based on their evangelical faith. And the record indicates on pages 115 to 122 that petitioner believes he was consistently targeted for harm and persecution by gang members because also, in part, his family ties.
Does the record have any evidence of the particular church that he belonged to taking public stands against the conduct of gangs?
Yes, Your Honor. The record on pages 112 to 117 demonstrates that petitioner actively engaged in evangelist activities with fellow members of his church in the broader community, and part of their evangelism was specifically targeted at ensuring that youth members of the community turn against the influence of criminal gangs in his country. So the record certainly demonstrates that the church took active steps to ensure that its teaching and its faith was well known to the broader community, and that faith being opposition to criminal gangs. Your Honors, I respectfully reserve the rest of my time for rebuttal.
Thank you, Counsel. Ms. Aldana?
Yes, good morning, Your Honors. It may please the court. Sarai Aldana on behalf of the Attorney General of the United States. The government asked the court to deny the petition for review as the petitioner has failed to establish that his harm was on account of a protected ground and that he will more likely than not be subject to torture with the acquiescence of the Salvadoran government. Regarding the nexus requirement, substantial evidence supports the agency's conclusion that the petitioner was harmed on account of general violence and gang recruitment efforts. Petitioner contends that because of his faith-based objections, he became a target to the gang. However, this is refuted by the petitioner's own testimony in that the petitioner explicitly testified that the gangs target all youths regardless of their affiliation, and he admitted that the gang's objective was to target him for recruitment. This can be found on page 124 and 140 of the record. Moreover, the petitioner indicated that he was attacked for being from a neighborhood of a rival gang. This is found on page 122 of the record. And in his declaration on page 387, the petitioner indicates that the problems began when the gang members tried to recruit him, and they would target him because he was from a controlled rival gang territory. Thus, as this court has made clear, criminal behavior or recruitment in general without more does not amount to a nexus to a protected ground, and thus the petitioner fails to establish eligibility for asylum and withholding. Regarding the withholding standard, the government asked the court to maintain its longstanding precedents employing the one central reason standard for withholding. And this can be found in the court's decision in Chica v. Holder, Alvarenga, Gonzalez Beltran, and Munoz Granados. Moreover, the petitioner's arguments within briefing, he presented no compelling argument as to why this standard should be imposed. Instead, he simply indicated that the board erred because it did not apply this standard. Therefore, the arguments that he brings before the court in first instance today should be considered waived and should not be considered by the court because within briefing, these issues were not addressed. Regarding the petitioner's CAT claim, substantial evidence also supports the agency's determination that the petitioner did not suffer torture in the past and any future torture would be speculative. All of petitioner's incidents were unrelated and isolated. There's no evidence demonstrating that the petitioner is still being targeted or that anyone specifically is interested in the petitioner's whereabouts. And moreover, he's not differentiated from any other single or young person within El Salvador, as admitted by himself in his testimony. While there is general evidence or conditions of violence, such conditions do not support a likelihood that petitioner particularly would be tortured, as supported by this court's conclusion in Courtroom. Moreover, there's news articles provided by the petitioner that describes how Christianity is growing in El Salvador and states that gang leaders respect Christian leaders and don't attack them. This can be found on page 363 of the record. Regarding the government acquiescence, here the record just does not compel the conclusion that the police or the Salvadoran government, after having knowledge of imminent torture, would refuse to attempt to prevent that imminent torture, especially in light of the fact that the record contains evidence that the Salvadoran government is working to combat gang violence and corruption. And this can be found on page 276 of the record, which indicates that legal reforms to introduce stricter prisons regimes and creation of the specialized reaction force of 1,000 police and military personnel to combat criminal gangs. Therefore, in sum, general allegations regarding the unwillingness of the Salvadoran police to investigate gang violence do not compel a conclusion. And in closing, the petitioner has failed to establish his eligibility for his forms of relief, even if the record were to support a contrary conclusion. In this case, it does not compel that conclusion. Therefore, government asks the court to deny the petition for review. Are there any questions?
Thank you, Counsel. Mr. Miller?
May it please the court. Respondents' arguments for affirmance fail for two reasons. First, because this court's precedent in shape does not require the court to hold today that one central reason governs nexus in the withholding of removal context, and petitioner did not waive these arguments in his opening brief. Second, because the evidence of record compels the conclusion that petitioner established the nexus one central reason standard for his asylum claim, and that he thus meets the lower burden of proof to establish a reason for his withholding of removal claim. Regarding the first point, Your Honors, a finding that withholding of removal has a lower burden of proof to establish nexus than asylum does would not contradict this court's precedent. Respondent just cited to this court's decision in the 2009 case Sheikh versus Holder to support the government's position that one central reason governs nexus in the withholding of removal context. But petitioner respectfully notes that there is no holding in Sheikh that requires this court to apply the one central reason standard to nexus in his withholding of removal claim. Although the court in Sheikh did assume without reason or explanation that one central reason governs nexus in the withholding of removal context, that issue was not briefed by the parties, and it was not in contention by the parties in Sheikh. As such, respondent continues to assert that there simply is no holding in that case, which would require this court today to find that his withholding of removal claim is governed by the one central reason standard. Additionally, respondent did brief this issue in his opening brief, and he further filed a 28J letter, petitioner filed a 28J letter apprising the court of the Sixth Circuit's decision in Guzman Vasquez versus Barr, which was issued after briefing had been completed in this case. So petitioner contends that this point is clearly before this court and that this court's affirmative decision on this matter is warranted. And second, Your Honors, my second point in response to the government's arguments is that the evidence of record compels the conclusion that protected grounds were one central reason for the persecution endured in this matter. Now, the government cites to evidence of the record and a variety of unfortunate experiences suffered by petitioner to support the general proposition that petitioner is a victim of random acts of criminal violence. Indeed, the record does show that petitioner has endured a variety of threats and acts of harassment, which are entirely unfortunate and all too often occur in his country. However, as this court once again noted in its decision in Edouard, a reviewing court is required to analyze what exactly events occurred in relation to the establishment of the nexus requirement to determine if an applicant for asylum and withholding of removal has met his burden. Additionally, under this court's 2013 precedent in Sharma versus Holder, petitioner would like to note that although an individual may not initially be targeted for a protected ground, if that protected ground becomes one central reason for the persecution throughout the course of the persecution suffered or endured, this court has concluded that an individual suffering such experiences clearly meets the one central reason nexus standard. And the facts of petitioner's case compel the conclusion that this is exactly what happened to him when he was in El Salvador. Again, the record on page 115 to 116 clearly shows that petitioner, although he was initially, it appears, targeted for a robbery effort by gang members, petitioner subsequently, after he was robbed and assaulted, informed his abusers that he could not join or be in a criminal gang because his beliefs and his religion precluded him from engaging in such misconduct. As a direct response to those affirmations, gang members beat petitioner and they threatened to kill him. This reality demonstrates that petitioner meets the one central reason and nexus standard. During this unfortunate altercation, once again, petitioner was not recruited by gang members. He had already been robbed by gang members, so they weren't furthering any other general criminal motive. Once again, the evidence of record in this matter clearly compels the conclusion that it was one central reason for his persecution was on account of protected grounds. As a result, Your Honors, petitioner respectfully requests that this court reverse the erroneous decision of the board and remand his case back to the agency for further proceedings.
Thank you, counsel. We have your arguments. That will conclude the arguments in front of the court today, and we recess until tomorrow morning. Thank you.
Thank you, Your Honors.